Welcome to Law and Society. Today I'm going to do a brief overview of Donald Trump's opening brief to the Supreme Court in the case of governmental immunity against criminal prosecution. So I will read through some portions of it, but just to give you a brief overview, Donald Trump makes extensive arguments that he has absolute immunity from criminal prosecution for official acts during his tenure in office. But his lawyers do little to counter DOJ's claim and DC Circuit Court's ruling that Donald's actions were criminal and therefore not official in nature. So, at the outset, there are many Donald's attorney in this filing over and over and over again talks about how former presidents and presidents have immunity from criminal prosecution for official acts, even official acts that are in the outer perimeters of his official duties. Well, the argument at the core of this appeal is that Donald Trump's actions were not official acts because they were criminal acts as enunciated in a criminal statute over which Donald Trump doesn't have any jurisdiction or power to or discretion to move about it, to skirt the different charges. It is the president's job to take care that the laws be faithfully executed. And the laws that he violated are exactly the laws that he should be executing, not violating. So, over and over again, Donald Trump's attorneys talks about a president's official acts can never be examinable by courts, and talking about Marbury versus Madison. And then in the statement of the case, he makes an erroneous and wrong statement here. He was indicted on 4 counts of alleged conduct, which charges President Trump with 5 types of conduct, all constituting official acts of the president. And that's false because the 4 criminal indictments for which Donald Trump has been indicted in DC are acts for which the president does not have any discretion to skip or to skip around those laws or to administer those laws. It is incumbent upon the president to enforce those laws. And here in this instance, Donald Trump has gone and violated those laws. And Donald Trump's argument for having violated these laws is that there were claims of election fraud, and he was doing everything he could to be able to rectify those claims of election fraud. The argument against that, one, is that there were 61 cases that went to the courts discussing and disputing election results, and they were all ruled against Donald except for one, and that wasn't outcome determinative in Donald Trump's elections. So Donald Trump did have the official ways of going about it, and he did. But beyond those official acts that he took, beyond what he was allowed legally to do, he went beyond and conspired to defraud the government, went beyond and conspired to obstruct congressional proceedings, and then he obstructed congressional proceedings, and he conspired to deprive Americans of their votes under the color of law, meaning under the auspices that he had the official duty to be doing those things, when clearly under Article 2 of the Constitution and the 12th Amendment, the president has no role whatsoever in counting votes. That power goes to the legislatures of the states and then to Congress. So at no point in the argument, in his brief, does he talk about how the elections are a domain where the president has no role, because what the argument, the crux of Donald Trump's argument is that everything he did, uh, while he was president in trying to overturn the election was actually part of his official act. When the other position is that it couldn't be official acts because they were designated by Congress as criminal acts that the president does not have any discretion to overlook, but only has the ministerial function as provided in Article 2 of the Constitution to take care that the laws be faithfully executed. So, uh, the Donald Trump's attorneys go into again the impeachment judgment clause and how that does not foreclose or put, because of the impeachment judgment clause, the president is not put above the law, but rather is uh, you know susceptible to impeachment, and without impeachment and conviction from the Senate, the president is immune. That is a tall order because that is an interpretation of the impeachment judgment clause that negatively infers that if Senate were to quit, then there can be no criminal prosecution. When that's not what the impeachment judgment clause says. It says that after going through impeachment and conviction of the Senate, the party shall nevertheless be liable for criminal liabilities. So it says then Donald's attorneys make a comment that generic criminal laws should not be construed to apply to the president or his official acts. That is an absurd statement. That why should criminal laws not be applied to the presidents? Why not? And it says, Donald's attorney says that the court requires an express statement before Congress, assuming it intended the president's performance of his official duties to be subject to judicial review. By the same token, textual silence is not enough to subject the president to the provisions. So it's saying that because Congress did not, in those criminal statutes, talk about how it was to be applied to the president, it does not apply to former presidents. These arguments are, they look like they are good arguments from a top that, they were his official acts, but the biggest place where Donald Trump's attorneys fail, and they don't even go there, is the claim that those criminal acts were criminal in nature that did not give the president any discretion to choose what to do and what not to do. And Donald's attorneys bring up previous administrations where they have conducted raids, and gone to Congress for authorization based on information that turned out to be false. Those actions by respectively President Obama and before that President Bush, they were done with the president's official role as the commander in chief. So comparing those actions to explicit violations of law like conspiracy to defraud and conspiracy to obstruct and conspiracy to deprive rights goes far beyond what the defense is saying that Donald Trump, has the ability to do. So effectively everywhere you see it says official responsibilities, the outer perimeters of the job, where he can exercise his own discretion. And later on in the argument, it says that everything is at the president's discretion. because even laws that are ministerial in nature leave something up to the discretion of whoever is, applying the law. And that makes that makes no sense, because Congress expressly makes laws that are applied to everybody equally. While the president enjoys immunity from criminal prosecution while he is president, that immunity goes away because the immunity stays with the office, not with the person. Now, if they have violated some ministerial statutes over which the president had no discretionary authority, like the president has when the president is the commander in chief. Here, the president isn't the elector in chief, or has not been designated any duty by the Constitution. So here, the president's job is to just take care that the laws be faithfully executed. And he doesn't do that. He violates them. And what that does is it attaches lack of criminal immunity. It makes them amenable to the laws if it is a ministerial act over which Donald Trump and presidents generally do not have authority to move around and decide on their own how to go about those laws. I mean, the opinion, the opening brief by Donald Trump's attorneys is just laid out with official acts, official acts, official acts, official conduct, official conduct, official conduct. And the idea is to inundate the court with saying that what Donald Trump was doing after he had exhausted all legal ways of going about the election voting procedures, he was doing his official acts. That's the crux of their argument, is that they were official acts, and they fell within the outer perimeters of the official acts if you don't think of them as official acts. But they don't fall into the outer perimeters according to the Constitution. I want to remind you that according to the Constitution, it does not give the president power under Article 2 and the 12th Amendment to do anything with the votes. That power is with Congress and state legislatures. What Donald Trump was trying to do was to coerce them and conspire with them to change election procedures as they stood at the time. And mind you, as a result of what happened, Congress enacted electoral law, passed amendment to the Electoral Act to clarify what the vice president's role is in counting votes. So the Congress has already taken action in limiting what the president can do, or what the vice president can do, what the executive branch can do in instances of vote counting. So Article 2, 12th Amendment, and the law that came right after Donald incited the insurrection, they all go towards showing that Congress did not give the president the power authority to do anything with the votes, with counting election votes. So there are many, whinings about, it would be liable for prosecution, and it would be perpetual ostracization from the esteem and confidence, and it, the very end, it sort of talks about what the lower court, the DC Circuit Court of Appeals, and DOJ's positions are, but they don't really. Donald's attorneys don't really go into why they were not official acts. Their argument is that those acts were official. But one other thing that's important is that they are also asking the court to remand the case to the lower court to determine the official acts, and asking this court to say that criminal immunity applies to certain extent and then let the lower court decide based on the facts whether the qualified immunity would protect Donald Trump from those particular acts or whether those particular acts were criminal of a nature for which Donald Trump doesn't have immunity. And it's a well-written opinion. It's a well-written opening brief, but in substance, it doesn't argue anything more than they argued in the DC Circuit. It doesn't counter why the acts that Donald committed were not criminal acts, except in saying that they were official acts because there were instances of election fraud. He was going to those people to ask them to rectify. Well, he doesn't have that authority. No, the laws, the Constitution explicitly does not give him that authority. The president's name is nowhere in the Electors Clause. It's nowhere in the 12th Amendment. So then he goes in, then Donald's attorneys go into the historical that this has never happened before. The original understanding draws further support from a 243-year unbroken tradition of not prosecuting former presidents for their official acts. Okay, not prosecuting former presidents for their official acts. And American history abounds with examples of presidents who were accused by their political opponents of allegedly criminal behavior in their official acts, yet none were ever prosecuted from 1789 to 2023. So the fact that some of them were engaged in criminal behavior, and then it goes into talking about how FDR had the internment camps and Bush lied to Congress about Iraq having weapons of mass destruction, and then Obama bombing places where there may have been American citizens. And these were all instances where there were allegations of criminal behavior during official acts. Mind you, the official act being they were the commander in chief and they were enacting powers on the basis of information they had as commander in chief. There is no position where the president is elector in chief. Therefore, the president does not have discretion to go into procedures of law of how elections are conducted. So that these examples fall short of what Donald Trump did, because they were all under official acts of the president as commander in chief. Here, then President Trump was not the elector in chief. He couldn't be because the Constitution doesn't give him that power. So that's, throwing around the blame to the other presidents for criminal behavior as part of their official acts. Well, in Donald Trump's case, they are criminal behavior that are not part of their official acts because they are vested explicitly in the other branch of government, Congress, and then to the states and state legislatures. So then it talks about, the having the privileges of the speech or debate clause, or how, having immunity from criminal liability is part of the doctrinal legacy of governments, of democracies. So I think that, the arguments that are being made here is talking about discretionary powers that are duties of his office. And what the government has said, and correctly so, and the DC Circuit correctly so, is that those decisions of elections do not fall anywhere within even the official outer perimeters of his official duties. So that's where the crux of the argument lies. And here, even Donald Trump's attorneys concede that remand the case for the questions of fact. but they want the Supreme Court to rule that there is some immunity and then remand. Whereas I believe that the stronger argument would be that the Supreme Court should rule that there's no immunity from criminal prosecution for acts that were solely criminal and not official under any law or provision in the Constitution. And that would be the correct way to go. And, I don't know if that's the way the Supreme Court is going to go, because this Supreme Court has, it has been both radical and originalist. It's just a rogue body, and it's difficult to determine how they would look at this. But the argument that a president is above the law and not subject to Article 3 courts for criminal acts that are not official acts has never been adjudicated before. And it's something that the Supreme Court needs to adjudicate now. Especially this whole thing about the discretionary and ministerial duties. The DC Circuit attempted to distinguish Marbury by holding that a president has a ministerial duty to comply with generally applicable criminal laws. The special counsel does not defend this distinction. The duty to comply with generally applicable criminal laws cannot plausibly be described as ministerial. Rather, it is quintessentially discretionary. The ministerial duty is a precise course accurately marked out by law, which is to be strictly pursued, which here in this case is Article 2 of the Constitution and the 12th Amendment, that states, Congress, and state legislatures and electors have the power of elections. That is why it becomes incumbent upon the president to not do anything there. And so also with the laws that explicitly say that these are conspiracies, there's no avenue in those laws where Donald Trump can skip about the conspiracy to defraud and use his discretion to do certain things that might be illegal in his run to see if there's election fraud. No, because he doesn't have any duty whatsoever in counting those votes, right? So that is a distinction that I think Supreme Court should make, is that there is no discretion or ministerial duty that the president has in counting votes. So that's the crux of the argument that they make, and how it's, let's see here. Now it says that prosecution or non-prosecution of a president is, in short, inevitably and unavoidably a political act, and therefore it must go through the impeachment process. And then if that Senate convicts, only then can that move into the Article 3 domain. They're making that up. There's no sort of basis for that. So I can say that this is a decently written brief, but it does not establish that the acts alleged were not criminal, and it contends that those acts were official, where in reality they are not official and they're criminal. It boils down to a very simple fact, and it's a determination of fact that the lower court has to make. The Supreme Court has taken this case, has given Donald Trump all the time he needs, but the ultimate question of fact of whether the acts committed by Donald Trump were part of his official acts, even in the outer perimeter, or that they were criminal acts and therefore not anywhere near the official acts or the outer perimeter of the official acts, that is the core question. And that is a fact-finding question. And I believe that the Supreme Supreme Court structured the question presented in such a way as to remand the case, obviously, with instruction of what they think of criminal immunity. And from this brief, the answer is there is immunity from criminal liability because those acts were official. But the counter argument is that there is no immunity because those acts were not official, not even in the outer perimeters, but rather criminal in nature and has nothing to do with president's official acts. So the doctrine of absolute presidential immunity from criminal prosecution for official acts, that says the court should order the dismissal of the indictment in its entirety under the doctrine of absolute immunity from criminal prosecution for official acts. So if, however, the court finds necessary to consider the extent to which criminal immunity applies here, the court may hold that criminal immunity presents a grave constitutional question, and a clear statement rules prevent the charged statutes from being interpreted to apply to the president or his official acts. So he's saying that congressional statutes don't apply to president. On its face, it kind of slaps the Constitution that says the president is to take care that the laws be faithfully executed, So statutes that do not apply expressly to the president must be construed as not applying to the president if such application would involve a possible conflict with the president's constitutional prerogatives. There are no constitutional prerogatives for the president to be counting votes. Therefore, the statutes do apply because they are not part of the president's constitutional duties. So, I'm skimming over this to talk about, and there are so many references to official duties that it wants to sort of blast it, and in doing so, push off DOJ's allegations that those acts were not official acts, that they were criminal acts. And mind you, the way that the Supreme Court phrased the question presented, it was asking that they were asking with the presumption that these were allegedly official acts. So the DOJ has to push back against that as well, that no, they were not official acts. They were not in a sphere of protected action that Donald's attorneys claim. So I don't see anything else that I would like to talk about in any detail from it. But suffice it to say, the argument boils down to the question of fact of whether his acts were criminal or official, and whether they were criminal behaviors part of an official act. The contention of the government is that they were criminal acts. They were not part of a president's official acts. They were actually acts that were designated to other branch of government, Congress, and to the states. And that is the government's argument, and that is the winning argument. But let me just say that the Supreme Court phrased its question presented in such a way as to presume that the alleged acts were official. And that perhaps would be why Donald's attorneys have literally littered their brief with the phrase official acts, official acts, official acts, official acts. And so the government has to counter by saying criminal acts and criminal acts and criminal acts and criminal acts with that and criminal behavior that was not part of any official acts. So with that said, it's 20-30 minutes gone. And hey, Derek, thank you for being here. Thank you for being here, everybody who has been here. And I will come back and talk about the DOJ's reply, because the DOJ will reply. And I don't know, I think the date is April the beginning of April. So stay tuned and please like, share, and subscribe. Thank you.